you, my lords. I'll turn now to the European Convention on Human Rights grounds. The first one is the absence of journalistic protections. I'm going to confine myself to one point only, mainly because it repeats across the grounds and it will save me repeating it later. Mr. Bunton will deal with the rest. The court already has seen the respondent's concession that the existing law doesn't provide for protections for journalistic sources in relation to bulk interception. But the respondents decline to make the same concession in respect of the other bulk powers, so say bulk equipment interference, for example. And the argument which is put against the appellant is that these powers are so different that that safeguard ought not be read across. We suggest that's simply an attempt to avoid the inevitable. The Secretary of State concedes that if you're going to use bulk interception to try and reveal a source, prior independent authorisation is required. But if you want to get exactly the same communications using, say, bulk equipment interference, perhaps because the communication was encrypted, so it needs to be decrypted using bulk equipment interference, then there's no need to get Judicial Commission authorisation. And our submission is simply that the Convention concerns itself with substance and not form, or the technical means by which the interception is carried out. So, to give a purely practical example, if a journalist sends a source or receives from a source an email or a text message, then using bulk interception, the identity of the source might be found. And it's conceded by the respondents that prior independent authorisation is required for that under the Convention. But if the source uses an encrypted messaging app, WhatsApp for example, the agencies may not be able to get the content of the message or all of the data, so they use bulk equipment interference in order to achieve exactly the same outcome and to obtain exactly the same information in relation to exactly the same communication. But, they say, no requirement for Judicial Commissioner authorisation. And the difference which is identified is it said, well, it's all different because equipment interference is about stored communications, whereas interception is different. The way my learned friends put it in their skeleton is they say that equipment interference is a backward-looking power. But exactly the same can be said of interception, because intercept can also be used to obtain stored communications. We looked at section 4 of the Act before the short adjournment. And equipment interference can be used in exactly the same way to obtain a communication as soon as it has been stored on the telecommunications system. So as soon as it's been stored on the sending phone, as soon as it has been stored on a server, somewhere in between, or as soon as it's been stored on the recipient phone. All of them are part of the telecommunications system. And Mr. Dix, in his statement we also looked at earlier, explains that the power can also be used for what he calls live monitoring. So a continuous feed of information, as soon as the data has been formally stored on a device, can be done using equipment interference. Now, that type of argument, which we say is the triumph of form over substance, has been run before by the United Kingdom in Strasbourg, and unsurprisingly we say it has failed when it's been run before. The most recent attempt to run a similar argument was in a case called RE in the UK about legal professional privilege. That's in the authorities bundle at tab 47, page 1659. This was a case in the Strasbourg court where, perhaps slightly optimistically, the United Kingdom tried to argue that the safeguards which applied if a telephone call between lawyer and client were intercepted did not need to apply if the same meeting had been held in person and the method of interception was bugging. The argument that was advanced by the United Kingdom is in paragraph 126 on page 1693. And the argument that's made is that there's a distinction between the minimum safeguards in interception cases and those in other surveillance cases. And this case concerns covert surveillance and not the interception of communications, so the test ought to be less strict. And that was because it was recognised that the case law on interception did require prior independent authorisation before accessing privileged material. And the court's response to that is in paragraph 130 and 131 on page 1694. So the principle is at 130. The third line says that the decisive factor will be the level of interference with the right to respect for private life, and not the technical definition of that interference. Unsurprising conclusion, we submit. And then paragraph 131 applies it to the facts of the case, and the court essentially finds there's no difference in practice between surveillance of legal consultations at a police station by bugging, which the court in the second line says is analogous to the interception of the telephone call between lawyer and client. So same type of argument, which was rejected by the Strasbourg court. There is also a suggestion in the respondent's submissions that extending the principle outside of bulk surveillance would be a breach of the principle in other. The idea that we don't go further than the Strasbourg court is willing to go. We say that would be incorrect. That is because that's an incorrect statement of the principle in other. The most recent version from the Supreme Court of how the principle is to be analysed and applied comes in the judgment of Lord Reid in AB. Lord Reid's judgment is at tab 10 of the authorities, page 362.
Page what?
362, my lady. The facts of the case don't matter very much. What's relevant is Lord Reid's statement of the other principle, which is at paragraph 59 of the judgment, page 387. I won't read it out, but if I could invite the court to look at paragraph 59, I'd be grateful.
59, did you say?
Yes. So we submit it's a fairly straightforward application of that principle, that some of the powers, for example, bulk equipment interference, have not yet come before the Strasbourg court because they're relatively new. But what the domestic court should do is to anticipate, if possible, how the Strasbourg court would decide those cases based on the court's existing established principles. And we say those principles can be found in Big Brother Watch and also applied to other surveillance techniques and the appropriate approach in RE in the UK. We don't say that any incremental development of the law is involved, but that is permissible if it's necessary. I mentioned that issue on the first ground because it does arise in the later grounds as well. That's all I wanted to say on ground 1. If I could turn on to ground 2. And ground 2 concerns the absence of various safeguards in the bulk
So
regime.
can I just check? That just seems to be part 6, chapter 2, and possibly part 7, or does what you've just said apply to part 3 and 4 and 5 as well?
What I've said applies to all of the bulk powers in part 6,
Yeah.
but also to part 5.
But not 3 and 4?
No, 3 and 4 already have a system of
Yeah, for journalistic safeguards, yeah.
yeah, to the extent necessary. And if necessary, actually, I've given the example so far relating to bulk equipment interference. The argument is probably a fortiori with a power like bulk acquisition. And the reason for that is that bulk acquisition concerns pure communications data, which can easily be used to identify a source. It's already accepted that prior independent authorization is needed if that's done under parts 3 and 4. But if you do exactly the same, get exactly the same data, which has been subject to bulk acquisition, using the bulk acquisition powers, then no prior authorization. There's not even any difference, even on a technical level, between the type of power or the content of the data that's being obtained. The second set of grounds concerns the absence of safeguards in the bulk regimes. The grounds of appeal have 3 parts to them. Just before I dive into them, it might be useful to have the grounds of appeal before the talk. They're in the 4 bundle at tab 17, page tab 1, page 17. So the first part of this ground, which is paragraph 5, is that in Big Brother Watch, the Grand Chamber said there had to be independent authorization of categories of search terms, also known as selectors, and that happens at the point of initial authorization, so the point of when the warrant is granted. Now, at present, there is, we say, no such requirement, either in the legislation or in the codes of practice. And the respondent's answer is that the operational purposes requirement in the statutes meets this requirement. What I'll do is I'll show the court the analysis in Big Brother Watch and submit that they do not. And that's an argument which we say applies across the piece to all of the bulk powers, not just bulk interception.
Okay, slightly out of step, but obviously we've seen that the decision was made in the second judgment to not only have the hearing but give judgment before the decision of the Grand Chamber in Big Brother Watch, even though the first section had already sent it. Was there any discussion, and there were some issues which were said to have to await, as it were, to have to await any decision on appeal. Was there any discussion in court about the implications of this? So as we're trying to look back and at the decision, the Divisional Court, and the decision that followed it, it could be said it might have been more convenient to wait for the decision of the Grand Chamber before litigating all these issues.
Yes, it might have been. I suspect, and I don't want to speak for the Divisional Court, but I suspect it arose from the fact that this claim was issued as long ago as 2016, and I think that the Divisional Court thought it was necessary as a domestic court to at least do the best it could and resolve the issues itself. And if ultimately some of its analysis was superseded or found to be wrong, then that might have to be considered on appeal.
Well, I note it was done by, it was common ground, it was described as in the judgment, that was the right course to take. And nothing, no further discussion than that?
No, I don't think so. And I think everybody recognised that that might ultimately be unsatisfactory because the law was likely to be a movable feast during the course of the litigation, and that was the obvious downside. The upside is that at some point, if there were objections that could properly be taken, that the court ought to rule on them, because it was unsatisfactory to have legislation in place for many years to which objection could be taken on convention grounds and EU law grounds. But I fully accept that it means that this court is considering some issues in essence for the first time, and that isn't obviously satisfactory. But I'm not sure there's any alternative.
Certainly not if litigation lasts as long as this litigation has. Yes.
I don't think the pandemic helped very much either.
Well.
And it's also fair to say that the Grand Chamber didn't hurry itself in giving its judgment.
Well, it wouldn't have made any difference because here we are in 2023 hearing the appeal.
Yes.
The Divisional Court could have given its judgment post-dating and we'd still be in the same position.
Yes.
Could have hurried this appeal up. There we are.
Well, sometimes I think it's evidence that the shortcuts mean that things take longer. I mean, I accept entirely what my lady says. I do see the difficulties, but what I can say is that we are where we are, and the alternative would be, I suppose, a new claim in the Divisional Court.
I'm certainly not encouraging that.
No, well, that's the disadvantage, and it would no doubt be said that we were perhaps out of time for challenging some of these provisions, given that a prompt claim was brought in 2016. So it was early 2017. I'm sorry.
And the Charter wouldn't apply.
And also the Charter wouldn't apply, yes, to a new claim. But it hasn't been, a point has not been taken against us that these points were not properly identified or argued in our original claim. And so we have continued to run them. We do say that, for example, prior independent authorisation is required across the piece, and that's always been our case. And the content of the law has changed as this case has gone on. That's the first aspect of the case. The second aspect of the ground is that the Grand Chamber found there needed to be objective internal authorisation of the use of strong selectors. So a strong selector is a search term that directly links to a particular person or a particular account, so like an email address or a name. There isn't such a requirement either in the legislation or in the Code of Practice. What my learned friend Skeleton has told us, I think for the first time, is that that has now been done in internal guidance. But that internal guidance has never been published or disclosed. And so we say it's necessary to do so. The arrangements are still not in accordance with the law because they're not accessible. They haven't been published as a formal rule or as a requirement. For example, in a Code of Practice, but it doesn't have to be a Code of Practice. And equally, those safeguards which the respondents say they have introduced in their internal procedures have not been applied to any of the other bulk powers. You've already heard my submission on that. And the third aspect of this ground is paragraph 7, which is the point that I've already started to develop about the difference between content and secondary data and the British Isles safeguard. And as my lady has already put to me, the common theme of all of the points under this ground is that they involve an argument about a failure to give effect to the judgment of the Grand Chamber. So now is probably an appropriate time to have a look at those requirements in the Grand Chamber's judgment. The Grand Chamber's judgment is in tab 56 of the authorities. If I could pick it up at page 2292.
5292.
I did.
Thank you.
So at paragraph 322, the court starts its assessment of the bulk interception issues and makes some preliminary remarks. And at the bottom of page 2292, the last two lines, the court says that safeguards are pivotal and yet elusive, and contrasts the position with targeted interception. And it's explained at the top of 2293 that bulk interception is used, perhaps even predominantly, for foreign intelligence gathering and the identification of new threats, and about the legitimate need for secrecy when such operations are being carried out. Then the court explains its approach, and at 324, the court starts by considering whether there's an interference with rights and what the interference is. And what the court says at 325 is that bulk interception is a gradual process, and the degree of interference increases as the process progresses. And the regimes may not follow exactly the same model, but there is a broad categorization that can be adopted, which is then set out. So the points at the bottom of 2293, there's initial interception, then there's the application of selectors, then there's the examination of the data by human beings, and then subsequent retention of the data and the use of the final product, potentially including sharing with third parties. So those are the stages of the process of bulk interception. Then at 327, the court defines what it calls a strong selector, and it gives the example of an email address. And then the court's conclusion at paragraph 330 is that Article 8 of the Convention applies at each of the above stages. And then it's explained the initial interception, followed by immediate discarding of parts of the communications, does not constitute particularly significant interference. The degree of interference with rights will increase as the process progresses. So, and of course, it's at its highest once the material is being examined by an analyst. Now, we say the logic of that is straightforward and impeccable, and it indicates why the court decided that the safeguards need to come after the collection of the large mass of data. The key practical safeguards are in the selection process and the examination process. The court then goes through its previous case law about surveillance, which is probably not necessary to look at now. But then on page 2297, paragraph 340, there's a heading of whether there's a need to develop the case law. And the court concludes there is a need to develop the case law. So paragraph 340, the court decides that bulk interception has always fallen and continues to fall within the state's margin of appreciation, something which states can properly do. Then but 341, it indicates that, this is the fifth line, its previous cases are more than 10 years old, there's been technological developments, and the scope of the surveillance activity being carried out appears to have changed. Then 342, the court refers to related communications data. This is the communications data that's swept up with bulk surveillance, and it concludes that more information is being obtained and the level of intrusion has increased. It explains why. And then 346, the court makes a point which I've already made, which is that while bulk interception is not necessarily used to target specified individuals, it can be and is used for this purpose. And then when that's the case, the individual's devices are not monitored, but the individuals are targeted instead by the application of strong selectors, such as their email address. So bulk interception can be used as an alternative way of targeting an individual. Paragraph 347 explains the obvious point that there is the possibility for serious abuse. and then the court identifies what it says are the appropriate safeguards. And the key ones for our purposes start at paragraph 350 on page 2299. In the second line of paragraph 350, the court refers to end-to-end safeguards. And then in the fifth line, that bulk interception should be subject to independent authorisation at the outset, and later supervision and independent ex post facto review. So in that respect, the Investigatory Powers Act got it right before this judgment, that Parliament realistically understood that that was the direction of travel, and the role of the Judicial Commissioner was introduced to provide for that prior authorisation. Paragraph 351 says it doesn't have to be a judge, it can just be an independent body. Well, Parliament has chosen a judge, but that's fine. The second set of new safeguards concern the selectors. And at paragraph 353, the court explains that the use of selectors, and strong selectors in particular, is one of the most important steps, and it's the point at which the communications of a particular individual may be targeted. Then the court's conclusion at 354, first of all, deals with how selectors should be dealt with at the stage of the initial grant of the warrant. And what the court says at 354, the last couple of lines, is that the initial authorisation must at least identify the types or categories of selectors to be used.
So that was in the context of the argument which was made at 353.
Yes.
Which was that both by the governments of the UK and the Netherlands,
that you can't authorise all of the selectors,
no.
And that would be unfeasible. And the
Yes.
court's response is, yes, well, we accept that,
yes.
but you must at least specify the type and category of selectors. So that's at the stage when the warrant is being drafted and the application is being made. And then 355 is the second new safeguard relating to selectors, and it's at the stage when strong selectors are being employed to find information about identifiable individuals. And the last three lines, there has to be a process of prior internal authorisation providing for separate and objective verification of whether the justification conforms to the aforementioned principles. So, when targeting a particular email address, a particular strong selector, you don't need to go back to a judge or an independent authoriser, but there does need to be at least a process of internal authorisation before a strong selector is used. And that's because you're effectively targeting an individual and getting an individual warrant, an individual authorisation at that point. Now, there was a breach of Article 8 found in that case because RIPA didn't meet any of those requirements. There was no prior independent authorisation. The court found that there was no prior approval of types or categories of selector, and there was no requirement for internal approval of strong selectors. So all of those were breaches. But what is being said in this case is that the requirement for types or categories of selectors is met by the operational purposes provisions in the Investigatory Powers Act. Now, the appellant's answer to that point is that those requirements and those provisions for an operational purpose are in essence exactly the same as the provisions in RIPA that were found by the Grand Chamber to be inadequate. The only change is that they have been given a different name. They're now called operational purposes, and previously they were called the reasons for certification. Now, to make that point good, it's necessary, unfortunately, to have a quick look at RIPA. RIPA is in the authorities bundle, tab 68, page 3201.
So which reference?
Tab 68, page 3201, and the provision is section 8 of RIPA is a rather briefer bit of legislation than the Investigatory Powers Act, and both targeted and bulk warrants are dealt with in section 8. So section 8.1 requires that a warrant has to name one person or a single set of premises as the target of the interception. So 8.1 is a traditional targeted warrant. It's slightly broader than it looks at first sight because person is defined as including an organisation. So it's very similar to what the Code of Practice now calls a thematic interception warrant. The warrant in subsection 2 had to set out the relevant addresses, telephone numbers and so on to be intercepted, and so again a targeted warrant. But under subsection 4, that requirement for targeting in subsections 1 and 2 shall not apply to an interception warrant if the description of the communications falls within subsection 5, that's A, and then B, a certificate has been issued by the Secretary of State certifying the descriptions of material, the examination of which he considers necessary, and so on. And that he also considers the examination of those materials necessary as mentioned in section 5.3 A, B or C, and those are the traditional grounds for interception: national security, serious crime, economic well-being. So the upshot of those provisions is warrants have to be targeted unless the Secretary of State issues a certificate, in which case they can be what we would now call a bulk warrant, and the certificate has to certify the descriptions of material which the Secretary of State considers necessary for national security, serious crime, economic well-being. And then the British Islands the Secretary of State under subsection 6 has to issue such a certificate under his own hand. So it has to be a personal approval. The other relevant provision of RIPA is section 16, which is page 3214. And section 16 introduces what we now call the British Islands safeguard in respect of certificated warrants, so bulk warrants as we now call them. And the British Islands safeguard is there in subsection 2 in almost exactly the same language. So,
sorry, could you just give me that last reference again?
Sorry, it's 16 subsection 2, and that contains the British Islands safeguard.
Page?
Page 3214.
Thank you.
So our submission is relatively straightforward, is that what the Investigatory Powers Act calls the operational purposes is the same thing as the old process of certification. Both are designed to limit what can be searched for within the bulk material. Both have to be referable to those three categories of national security, serious crime, economic well-being. And so the substance of the legislative scheme, we say, has not altered from the position as considered in Big Brother Watch. And we say that that is confirmed by the reasoning given by the Grand Chamber in Big Brother Watch. So just going back to that judgment, where the court analyses this issue in a bit more detail, if I could start at page 2233 of
before you do that, can you just give me the cross-reference to the relevant sections of the IPA?
Yes. I'll give you one. I'll give you the bulk interception provisions because that's most directly analogous. The requirement for operational purposes is in section 142. That is on page 2796. So just going back to Big Brother Watch,
Yeah.
On page 2233, there is a long quotation, whole of the page, from the Code of Practice, as it was under Divisional, where there is an explanation of the effect of the certification requirement.
So which paragraph of Big Brother Watch?
And it's paragraph 6.14 of the quotation.
Yeah, I'm not even on the paragraph, even on the sub bit.
Sorry.
Page or paragraph of?
Big Brother Watch, page 2233.
Yeah.
And the whole page
Yep, got it, yeah.
is a quote from the Code of Practice. And paragraph 6.14 deals with the process of certification, which we say is analogous to operational purposes. So the warrant has to be accompanied by a certificate, and it has to be for one or more of the section 5.3 purposes, and we've looked at what they are. And the purpose of the certificate is to ensure a selection process is applied to the intercepted material, so that only material described in the certificate is made available for human examination. The certificate must broadly reflect the priorities for intelligence collection set by the National Security Committee with the guidance of the agencies, and then it gives some examples. It might be intelligence on terrorism, as defined in the Terrorism Act, or controlled drugs, as defined in the Misuse of Drugs Act, and the Commissioner must review any changes to the descriptions in a certificate. So that was what the Code of Practice said under RIPA, and it's, again, we say essentially exactly the same approach. It has to be more specific than merely saying national security, but it doesn't have to be any broader than a general priority for intelligence collection, something like terrorism or controlled drugs. That's sufficient. And the Grand Chamber's conclusion was that that degree of specificity was not enough to meet its requirement of specification of categories of selectors. And the court dealt with that from paragraph 382 onwards. 382 is on page 2307. So paragraph 382 is the finding of breach. Given the choice of selectors...
Before you get there, if one looks at 142 subsection 7, your argument on that is that doesn't take it any further.
Yes.
Is that it?
Yes. The reason for that is that all 142.7 does is require a greater level of detail than the words national security, serious crime or economic well-being. That's all section 1381B or 2 requires. That's the only requirement, and that requirement is exactly the same in RIPA, because the certificate has to be for the reasons set out in section 5, which obviously means it has to be more specific than those reasons themselves, but no more than that.
You're saying it's a more refined purpose or sub-purpose, but it doesn't get to categorisation of selectors. I understand it.
And that's the conclusion which the Grand Chamber ultimately reached, because it had the Ripper scheme in front of it. So paragraph.
Could you give? I'm very sorry. Could you give the page reference for where you are?
Yeah, sorry, page 2307.
2307.
Sorry, 2307. I apologise.
That does make a difference. My mistake. 2307.
Fortunately, it is a bundle that does go as far as 33. So 382 contains the court's finding of breach. Given the choice of selectors and the query terms, determined which communications would be eligible for examination by an analyst, the court has indicated it's of fundamental importance for at least the categories of selectors to be identified in the authorisation. And then they make their other points about strong selectors to be subject to prior internal authorisation. And then 383, the deficiency in the Ripper scheme is identified. Absence of oversight of the category of selectors at the point of authorisation was a deficiency in the Ripper Section 8 core regime. And then they deal with the other issue related.
And in 383, does it follow from what is said in 382 that prior internal authorisation would do for strong selectors?
Yes, it does, and indeed that's absolutely right. And that's the only case that we advance in relation to strong selectors at the point of introducing them and applying them to the bulk data. So there's two separate points being made by the court. The first point is about categories of selectors in the warrant and that they need to be approved independently. So that's at the early stage of making the warrant. And then the second element of safeguard is that once the data has been obtained under the warrant, if you're going to apply a strong selector to it, then you need internal authorisation, but not independent authorisation for that.
So categorisation selectors, you need independent pre-authorisation.
Yes.
If using strong selectors at the next stage.
Once you've got the data, if you want to type in Ben Jaffe at blackstonechambers.com, then you need internal authorisation, for example. And I'm just at the point about the categories at the moment. Yep. And finishing that off. The court then considers whether the certificate under Ripper was good enough, and the court does that at paragraph 386 on page 2308. And the court's conclusion, I won't read out the whole of 386, but I invite the court to read it, is that the certificate can be couched in two general terms, and so the certificate doesn't do that job.
Do we get any help from the Divisional Court? Because in this case, looking at that last part, agrees with the, I think it's agreeing with the first section, isn't it?
No, unfortunately, I don't think the first section, in fact, went quite as far as the Grand Chamber on this issue.
Right.
Whatever they may have said. And so, unfortunately, we don't really get any help, I think, from the Divisional Court. The Grand Chamber, over the page at paragraph 387, then repeats the same conclusions in slightly more detail, and again concludes in the last 4 or 5 lines that the certificate was not enough to provide independent authorisation of the categories of selectors. It's not the same thing.
So I'm just trying to understand what 387 says. It was the selection of the bearers that I understand to be the routes over which the communications are carried.
Exactly. So it might say a particular fibre optic cable from place X to place Y.
The application of simple selectors and initial search criteria, the things that fix the parameters of the bulk search, is it?
No, I think the court it's quite a long sentence, and the court deals with two things there.
Mm-hmm.
So the first part is, although the certificate, and I would add did, set out the general categories of information which could be examined, in practice it was, and then the selection of the bearers, the application of simple selectors, initial search criteria, and then complex searches, which determined what communications got looked at.
Yeah.
And then the court explains that the certificate regulated the selection from a computer-generated index. And then the court has already held that the failure to identify the categories of selectors in the application and prior internal authorization of those strong selectors linked to an identified individual were a breach. And then that's all exacerbated by the Secretary of State's certificate being very general. And then the court repeats that there was no prior independent authorization of the categories of selectors.
But what I'm wondering is whether the category of selectors that they're talking about is the same as the choice of bearers and selector search terms.
Well, the answer to that is it may not be I don't know. But one thing the court is saying is that the certificate was not good enough.
No, I understand
to meet that requirement.
Yeah, and it wasn't good enough because certain things weren't there, and they should have been at the beginning stage. I'm trying to find out what the certain things that weren't there. Because categories of selectors is one thing, but what does it actually mean? It may mean the communication routes.
Well, it can't mean that, because the selectors by category are the techniques of search and the search terms which are being used to sort the mass of bulk material and select what it is to be examined, that is, read, looked at, or listened to by a human. So that is what the selectors are for, and they explain that that is the purpose of selectors, to winnow down the material in order to find the type of material you're looking for. And what the court is saying is that general terms such as terrorism in a certificate are not sufficiently precise to amount to a category of selector. When I can probably attempt to give some examples of what we say a category of selector might be. Let's say, for example, within the concept of terrorism, which is not enough, a category of selector, that is a category of search term, might be queries to identify those people who have read extremist material. That would be a category of selector. It wouldn't tell you what the selectors are, because they would be very complicated and have many parts and would change regularly. But the category of selector would be within the operational purpose of counter-terrorism, identifying people who read extremist material, or identifying people who sought to look for explosive components online.
And that's got to be in the application for the initial bulk interception warrant.
Yes.
But then once you've got that, if you're going to look at individuals who are reading the bomb-making section, that's the internal authorization.
That's right.
The internal prior, yeah. Exactly. Okay, I've got it now, I think. Sorry about that.
So it's not necessary at the initial stage to identify the actual selectors being used. You can talk about categories. Now, I've tried to give some, and they are, of course, just hypothetical examples.
Yeah.
But those are the types of, that's the type of specificity which we say the court is getting at. And there is, we say, a pretty clear difference between a broad operational purpose, which says nothing at all about the categories of selectors being used, and a category of selectors. Another example might be that it would be a legitimate operational purpose to have something like the United Kingdom's response to the pandemic. Now, one could easily see how that could be described as a matter of national security, given its importance to national life, but it isn't a category of selector. The category of selector might be analysing transmission by reference to communications referring to symptoms. So it would be possible to track the passage of the pandemic around the world by looking at bulk communications to see who's describing symptoms in their text messages and what they are. That would be a category of selector. But the operational purpose is much broader and is different.
Would it follow that by the time you've got to your further stage of winnowing down or narrowing down the category of selectors, that if it passed muster at that stage, it would have passed muster at the earlier stage?
That will depend. So if, for example, you have a category of selector, and we take the terrorism example, looking for people who read extremist material online, that may come back with a list of potential targets. But those aren't strong selectors. If you decide then that, oh, I'm particularly interested in that person, and I'm now going to go and collect all of their email, because they're obviously a person who reads a lot of extremist material online, and I'm going to target their email address and their phone number, those are then strong selectors at that point. And that's the point at which, once you're targeting an identified individual, the Grand Chamber says you get internal authorisation.
I mean, I think this is detailed, and it's probably not for us at all, but one could say the category is websites dealing with extremist material or websites dealing with bomb-making material. The strong selector would be people reading those websites. So all you'd have in the warrant would be, we're looking for bomb-making or radical literature, and then it would be the internal authorisation to check which people are reading them.
Yes, I think there may be a terminology difference between my lord and the Grand Chamber.
Oh, right.
The Grand Chamber in paragraph 383 defines strong selectors as being linked to identifiable individuals. And that's the last two lines of
It's not who is reading, it's is Mr. X of To the Cuttings reading.
Yes, once you're looking at the activities of identifiable individuals, then that's a strong selector. Where you're just, for example, looking generally at new targets, who is reading extremist material online, ? That's not a strong selector.
Yeah, okay. It probably doesn't matter because that's a level of detail that's not for us.
Now, the reason we say why this safeguard exists and why it's been required by the Grand Chamber is it's so that the Judicial Commissioner can examine the lawfulness in general terms of what's being proposed and whether or not what is happening is necessary and proportionate. Because otherwise, and without that information about the categories of selectors that are going to be used, it's very difficult for either the Secretary of State, who of course has an important constitutional role in granting or refusing these warrants, and then essentially the judicial review by the Judicial Commissioner, to proceed on an informed basis of, at least in general terms, what is going to be done with this data. We say that the absence of such a requirement copies across into the scheme of the Investigatory Powers Act, and it also copies across into all of the bulk powers and not merely bulk interception.
So it's not enough that he knows they're looking for terrorism. Yes, that's a good thing. Yeah. They're looking for people who are reading websites on bomb making and radical literature, and the Secretary of State will know that that's what she's authorising. It's to sharpen up the authorisation process.
It is, and so the authorisation process is more meaningful, and the Secretary of State's consideration and also the Judicial Commissioner's consideration of proportionality is more meaningful.
More informed.
Yes. And that's because in reality, if a Judicial Commissioner is presented with a warrant application that says we would like to target the following 6 fibre optic cables which contain X% of all the communications going in and out of the United Kingdom, and we want to do so for the following operational purposes, namely something as broad as counter-terrorism and some others, international espionage and misuse of drugs, that gives the Judicial Commissioner very little in practice to go on. That you have independent authorisation, but it's not a meaningful review of the proportionality of the decision, because, okay, you've got all that information, yes, you're going to look at it for purposes of counter-terrorism, but how are you going to analyse that data, and how are you going to restrict its usage to ensure that the purposes are proper? That's why the Strasbourg Court is imposing that minimum safeguard, we say. We also say it's not onerous or impossible. The court heard submissions about what would be too onerous and didn't adopt the most onerous approach. So that's at the warrant granting stage. The next stage, and the second part of the argument, is about internal authorisation of strong selectors. Now, the respondents accept, in relation to bulk interception, that in the past this was not done, and they accept that in the future it must be done. But again, they refuse to accept that the other bulk powers are materially identical. For the reasons I'm not going to repeat, we say they are. If anything, of course, some of the other bulk powers may be more intrusive than bulk interception. So, just by way of example, bulk equipment interference can be more intrusive than bulk interception because it can also be used to get information on our computers or on our devices that we have deliberately chosen not to communicate. So, a diary, private photos, work in progress that we're not ready or in a state to send to anyone. All of those may involve a greater intrusion into privacy than bulk interception, done through bulk equipment interference. So the idea that the safeguards ought to be less in relation to a potentially more intrusive bulk power is, in our submission, counterintuitive. What the respondents also say on internal approval is that they have now made a change to their internal procedures to provide for that. That's what we're told in their skeleton argument. But the internal policy itself has not been disclosed. The code of practice has not been amended to reflect the change. And as a result, we make the, I suspect, obvious submission that the requirement that the law be accessible has not been met. And this is something which again happened in the Big Brother Watch case. The details of an internal rule were disclosed in the course of the litigation, and the Grand Chamber found that that was inadequate to provide for a proper degree of accessibility of the legal safeguards. Take that point from the judgment at paragraph 423, page 2317. The issue at paragraph 423 is the court was considering the retention period for certain categories of data. And halfway through paragraph 423, the court notes that the periods were only disclosed in the proceedings before the court, and so the shorter periods were not evident to someone reading the Code of Practice. No indication in the Code of Practice that retention periods for related communications data were different from those of content. And in the court's view, in order to meet the requirement of foreseeability, the retention periods disclosed should be included in appropriate legislative or other general measures. Now, there are lots of ways of doing that. It could simply be publication of the relevant rule. It may need to be redacted if there are some sensitive details as to exactly how it's implemented, or it could just be added to the Code of Practice, which is the normal means of dealing with such issues.
What would need to be published? The fact that there's internal authorization, that's all you've got to say. There is a system of internal authorization of strong selectors when prior to examination by analysts or others of the information. That you really need one sentence, wouldn't you? Here it was different because they needed to know the months.
Well, the Code of Practice, for example, would need to say that there is a requirement for analysts to seek internal authorization at a higher level, for example, before applying a strong selector. And that would need to be included not just in the procedures relating to bulk interception, we say, but also in relation to the other bulk powers. So if it is just one line, and of course it can be encapsulated briefly, but nonetheless it is an important rule.
Yes, but that's all that you're looking for.
Yes.
Mm.
To be entirely fair to the respondents, they've said this is something we can do, and in relation to bulk interception, this is something we agree to do. They don't accept it in relation to the other bulk powers. But
They're going to do it for chapter 1 of part.
they're going to do it for chapter 1 of part 6, and we say that's all very well, and as the Strasbourg court said, it is important that the rules, and these are the fundamental safeguards for the protection of private information, ought to be in an accessible form. And ultimately, merely saying something in the course of litigation is not a sufficiently accessible form, because compliance with the basic safeguards ought to be in a form that's available to the general public in a straightforward way. And in this country, we normally do that in a code of practice. I don't say it has to be a code of practice. It could be primary legislation, could be secondary legislation, it could be a published policy or rule. But nonetheless, it does have to be done in some formal method. And that's because in the field of secret surveillance, the existence of the safeguards and the public availability of those safeguards is a matter of importance. And it's not enough simply to say that the material is in some way, that there is some form of rule and it's been applied in a general sense. The final point under this ground 2, is about the difference between the treatment of content and secondary data. And these are points that I've really already developed whilst going through the legislative scheme. The effect of the provisions that I took the court to this morning is that much material that is the substance of the communication between people will be treated as secondary data and not as content, and that the British Island safeguard and also some of the other safeguards, such as for legal professional privilege, do not apply. And that provision is worse than the situation under RIPA. And the reason for that is that under RIPA there was no concept of secondary data, which is defined in the broad way which I sought to develop in my earlier submissions. In RIPA, all there is a traditional concept of communications data, which doesn't include any of the substance of the communication that secondary data, systems data, does. Rather than do a 10-minute trawl through the annals of RIPA, can I just simply say that that's the effect of section 20 and 21 of RIPA, and if that's disagreed with, I'll come back to it in reply. The defect which arises here is that we say no basis or no rationale has ever been put forward as to why those safeguards were properly reduced. Now, I know their friends say in their skeleton argument, well, yes, this material may well be often less sensitive than content as defined. That may well be true in some cases. But what has not been explained, we say, is why far more information has been removed from the British Island safeguard and also, to an extent, the legal professional privilege safeguard. And that material that previously would have been treated as content is deemed not to be. And our short submission is that there is no justification for that. So those are the points which we make under ground 2. The third convention ground concerns the sharing of material with overseas authorities. There are two kinds of potential sharing of data that might take place. There's incoming sharing, where data is received from an intelligence partner abroad. That's not what this ground is about. What this ground is about outgoing sharing. So where data is obtained under the Investigatory Powers Act and the intelligence services give access to that material to another state. And the Grand Chamber in Big Brother Watch dealt with both types of sharing. But the outgoing sharing parts of the Grand Chamber's judgment are at paragraph 362 on page 2302. Page 2302, paragraph 362. So in this paragraph, the court sets out what it says the basic requirements or the safeguards are on outgoing sharing. And the court explains that it hasn't yet provided specific guidance on this issue. It's clear that some states are regularly sharing material with their intelligence partners, and even in some instances allowing those intelligence partners direct access to their own systems. Some of the evidence before the court was about the United Kingdom doing that in relation to its Five Eyes partners. And the court considers that transmission by a contracting state to foreign states obtained by bulk interception should be limited to such material as has been collected and stored in a convention-compliant manner, and should be subject to certain additional specific safeguards pertaining to the transfer itself. And then they're set out. The circumstances in which a transfer may take place must be set out clearly in domestic law. Secondly, the receiving state has in place safeguards capable of preventing abuse and disproportionate interference. Receiving state must guarantee secure storage and restrict its onward disclosure. Doesn't necessarily mean the receiving state must have comparable protection to the transferring state, nor does it necessarily require that an assurance is given prior to every transfer. And then thirdly, heightened safeguards where the material requires special confidentiality, such as confidential journalistic material, and the transfer material has to be subject to independent control. So those are the list of safeguards. And the submission which the appellants make is that the bulk powers don't contain those mandatory requirements.
And just to be clear, that's 5, 6 and 7. Parts 5, 6 and 7.
The shortest version of this argument is in relation to Part 7, which is bulk personal data sets, which makes no provision in the legislation for supplying data sets to overseas authorities. And the code of practice for bulk personal data sets doesn't contain any of that list of requirements either.
So we could hand over the manifest of flights to Karachi or whatever,
Or the health database.
Or the health records to another state without any safeguards, you say?
We're not saying it can't be done, and we're not saying it shouldn't be done. We're simply saying that these safeguards ought to be in place before it is done.
Yeah.
As for the other bulk powers in Part 6, there is a provision in the Investigatory Powers Act, or there are provisions in the Investigatory Powers Act governing this, but our submission is that those provisions are not adequate. So I'll use bulk interception as my main example, as I've done before. So I could ask the court to have a look at section 151 of the Investigatory Powers Act. Section 151 is on page 2805. So section 151, subsection 1, starts off in a fairly promising way. The Secretary of State must ensure, so it's a mandatory duty, in respect of every bulk intercept warrant, that arrangements are in force for securing that any material obtained under the warrant is handed over to overseas authority only if the requirements of 2 are met, and that copies of any such material are given to overseas authorities only if those requirements are met. And then subsection 2, what we're told is that the requirements of this subsection are met in the case of a warrant if it appears to the Secretary of State that requirements corresponding to some other provisions will apply, and then this, to such extent, if any, as the Secretary of State considers appropriate in relation to any of the material which is handed over, etc., etc. So some of the safeguards can be copied across, but only to such extent, if any, as the Secretary of State considers appropriate.
But if he's got to meet the requirements of BBW, Big Brother Watch, then he could not consider it inappropriate to make those, couldn't he? He's got to exercise his discretion in accordance with Article 8 and 10, and if you couldn't say it's not appropriate to do that, the answer would be, well, of course it is. You've got to comply with the convention.
Yes. In a public law case, that is what you would say. However, because this is a rule relating to interception, what is necessary is that the law, that is the requirements and the safeguards, need to be set out in binding provision. Now, they don't have to be statute, they can be a code of practice, for example, but there has to be a provision or a rule which restricts the exercise of the discretion of the Secretary of State. Now, those provisions which are referred to, section 152 and section 155, are a series of very basic requirements. They're about minimising the number of copies which are transmitted and the number of people who are allowed to see the copies, and secure storage and eventual destruction. There's no provision here for confidential journalistic material or privileged material. There's no provision in relation to onward disclosure.
Just thinking practically, I just wonder what sort of thing one could put in place in relation to material which is, you know, say all the right things, but once it's out of your hands, it's out of your hands.
Well, the starting point is...
And how would you police it?
The starting point is that it is necessary as an absolute minimum to say all the right things and do all the right things. And without at least that, there's no possibility of the information.
I follow that, but I just think anything in practical terms.
And being practical, that is really what this issue is about, because the sharing of bulk data, not an individual intelligence report, not a one-liner from GCHQ saying we have analysed intelligence that indicates that a terrorist attack by this person may take place at this place and you may wish to go and arrest them. That's one thing. This is handing over the bulk data, which can then be used by the recipient authority and searched by the recipient authority for its own purposes and in its own way. So inevitably, as my lady says, much more difficult to police. And that's why, if anything, the standard of the safeguards needs to be higher rather than less in relation to intelligence sharing. And that's why this was a matter of concern to the Strasbourg court.
May I just understand that I understand what you're submitting? There are 4 requirements set out in paragraph 362 of Big Brother Watch, and section 151 subsection 2 refers to other sections which has various substantive requirements in, and I'm not sure at the moment whether you're saying those other requirements don't cover everything in 362, or whether you're saying it doesn't matter whether they do, it still has to be considered appropriate, and those words remove the protection of the law, or 3 something else.
It's 3 both, I'm afraid.
Oh, right.
Sorry.
So it doesn't cover the ground,
so
and having the is appropriate negates it of protection.
Yes. So where it doesn't cover the ground is it doesn't cover confidential journalistic material or privileged material, and there's no provision on onward disclosure.
Yeah. And the is appropriate denies it of legal force.
Yes. And the if any, in any event, deprives it of legal force and doesn't make it a requirement.
And does 362 cover then confidential journalistic material and legally protected privileged material?
Yes, it does.
Because
3 lines up from the end of 362, material requiring special confidentiality.
oh, okay, there it is. Yes, sorry. Yeah. Okay. Yes, I was just reading it then. Okay, thank you very much. I'm so sorry.
Yeah, no, that's good. It's quite all right. The striking thing here again is actually the position has got worse once again since Ripper rather than better, because in the Big Brother Watch case, the court found that these minimum safeguards had in fact been complied with as a result of the content of the Ripper Code of Practice. The Ripper Code of Practice made provision for each of these points, and therefore the arrangements were lawful. And the court made those findings at paragraphs 396 to 399 on page 2311. I won't read that, but the court just goes through all of those minimum requirements it's identified in 362 and cross-references them to the interception of communication code of practice and puts a tick by each of them.
Which, if any of these, have remained?
Yes. Can I show you the new Investigatory Powers Act code of practice? That is in tab 90 of the authorities at page 4451. I should add this is a new code of practice, and it was approved by Parliament in December 2022, so December of last year. So it postdates Big Brother Watch.
Is this 4491 of the Appellant's Authorities Bundle?
4451 is the relevant page.
So postdates Big Brother Watch.
Postdates Big Brother Watch. And the heading on 4451 is safeguards relating to disclosure of material overseas. And this is entirely different drafting from the drafting of the Ripper Code. And the relevant provision is 9.27. and then the 3 bullet points, if any, simply repeat the legislative wording, including the if any provision. And then in paragraphs 9.28 and 9.29, there's an explanation. So there's a requirement to impose certain safeguards to the extent appropriate where the material obtained under a warrant is being shared with an overseas authority.
Just expect, why is it unsatisfactory to say to the extent appropriate?
The answer to that is because there are no rules which are binding in any sense, or which even refer to the existence of these minimum safeguards identified in the Big Brother Watch case. So there is no accessible rule which constrains the exercise of the Secretary of State's discretion.
Well, what about Section 6 of the Human Rights Act? It's a good rule.
Yes, but it is a rule, but otherwise it would not be, if that were right, it would not be necessary to have any surveillance law. It could simply be the Secretary of State may grant a warrant which has to be approved by the Judicial Commissioner.
No, because this is a very specific point. There's one thing whether it covers everything. Your argument here is that it's denuded of the quality of law by virtue of discretionary language. And I'm saying no, because that's not the only relevant principle in force, and its legal virility is preserved by Section 6.2, by Section 6.1 of the Human Rights Act. If that's all you'd had, but you can't just look at one bit of the law of England or Wales, or even Scotland or Northern Ireland. You've got to look at all of it. And any lawyer in England or Wales would know that you've got to read the code with Section 6.1. And you could only treat it as appropriate if you didn't breach another rule, that of Section 6.1. Otherwise, the world becomes terribly complicated.
Well, that is correct as a matter of domestic public law.
Mm-hmm.
However, the difference is, and I'll take my law to some of the authorities in Strasbourg, but the Strasbourg authorities have made clear that the requirement is for the safeguards to be available to the public and accessible and therefore foreseeable on the face of some form of binding instrument.
Yeah.
And a binding instrument is slightly more than, for example, a general obligation in the Human Rights Act to
It's
provide
not
the
an
safeguards.
obligation, it's the code and the Human Rights Act. It's both of it, I'm saying.
But if that were the case, then it would not be necessary, for example, to introduce any changes at all following the Big Brother Watch judgment. And that would be because it would be possible simply to say, well, the warrant can't be granted, and consistent with Section 6 of the Human Rights Act, there's no need to make any change, because if a warrant is granted, it will always be done so compatibly. So it's where the court identifies specific safeguards which are relevant and need to be applied, the public authority and also the public need to have an accessible statement of what the requirements are. And simply saying that the accessible statement is the judgments of the Strasbourg Court from time to time as read consistently with Section 6 of the Human Rights Act.
That's not what I was putting to you. I'm saying it's Section 151 and the other sections to which it refers, plus the code, and if your sole concern is the words as necessary or as appears appropriate might be thought to denude that, those little words can be easily trumped by the ace of spades, the Human Rights Act. So I'm not saying so long as you've got something in Strasbourg and the Human Rights Act, that's enough. I'm saying if you've got sections in an act plus the code and your concern is the apparent appearance of discretionary powers, that last little bit of the jigsaw can be nullified. That's all I was asking, whether that wouldn't be enough. I've got your submission.
You've got my submission that it's not enough.
It's not enough.
You've got my submission that it's not enough. But I do also say that where the Strasbourg Court identifies specific safeguards that are required to be in place, the reality is that they ought to be in the form of some kind of binding rule or instrument which people can see and know is being applied and applied. And that is because the Strasbourg Court has treated surveillance cases as slightly different from other categories of cases. And the reason they treat them in a slightly different way and do require statements of rules and safeguards is because whether or not someone is under surveillance is something they will entirely properly, usually never be told. So the only safeguard a member of the public has is to be able to say, well, look, these are the rules, and because there are binding rules in a code of practice or wherever that I know will be applied to me, I can be satisfied that any conduct against me, and I won't be told if it is happening or not, is being conducted lawfully. And that's why the more traditional English public law approach, which my lord is definitely properly putting to me, isn't one that has found favour in the surveillance cases. Then paragraph 9.29, finally, it said that there will be occasions where material derived from warrants may need to be shared with a country overseas with whom we don't have an existing sharing relationship and whose authorities do not apply safeguards to intercepted material corresponding to those in the Act. Issuing authorities will need to consider the arrangements that should be in place. They should require the person considering authorising to balance the risk that this material will not be subject to the same level of safeguards that it would be in this country against the risk to national security if the material is not shared. Now, this is all new wording, and again, this links to the point I was just discussing with my Lord Justice Lewis. This is actually inconsistent with the idea that there are minimum binding safeguards that must always be complied with in relation to foreign sharing. This is suggesting that ultimately any requirement can be got rid of applying a balancing act, balancing the interests of national security as against the appropriate level of safeguards.
Would it be possible to express that legitimately in a different way? Saying these are the minimum standards, but they can be abrogated or circumvented in particular circumstances.
I think what you can say is the appropriate level of safeguards must never fall below this minimum. But providing that minimum is met, it can be calibrated depending on the circumstances. And that's what the Strasbourg Court said in 362.
This minimum being what for this purpose?
The requirements in paragraph 362 of the Grand Chamber's judgment.
But
929 is dealing with the situation where we don't have existing arrangements, so it's a different category of countries. It's not saying if we've got relations well established, we can dispense with them. It's saying what happens if we want to give it unusually to a country that we don't have relations with. Then we've got to have arrangements in place, and these will need to disclose balanced disclosure that they won't be subject to the same level of safeguards, i.e. my lady's point, what happens if you give it to them for the first time and you think, yeah, they look okay, and the next morning you read in the international news of the world that in fact they've handed it over to the people you don't like. That's what that's dealing with, isn't it?
Yes, it is. But what it doesn't say is that there must, for example, as a minimum, be and this is what I said in 362, be requirements for secure storage, and there must, as a minimum, be requirements in relation to onward disclosure, which normally.
And you say there's nothing in terms of national security that could ever justify that sort of scenario, because it must always be the case. If one reads what is in 362, that the balances that are set out in there must be struck in that way, whatever the situation with regard to national security.
Yes, and that's because, for example, there are some irreducible minima of things that the Human Rights Act will not normally permit information to be used to achieve. So let's say, for example, that there was a possibility that the information might be transferred to another state to be used for identifying people to torture.
Well, I was just thinking about that, but you wouldn't, well, I don't know, but you wouldn't expect to find that specified in the Act as a necessary irreducible minimum, would you?
No, what you would find is only what's in 362, that there ought to be restrictions on onward disclosure. Now, picking up my Lady the President's point, those restrictions might or might not, by a friendly foreign state, ultimately be complied with, and that can't be forced. Other states do what other states do. But as a minimum, you can impose those requirements. So you can say, I'm giving you this data, but you mustn't transfer it on to any third state.
Well, I just wonder if this paragraph isn't doing something different. It's saying there are going to be countries that we don't have arrangements with, and we've got to think about that. it's not setting out the minimum safeguards. It's saying issue authorities will need to consider the arrangements that should be put in place to regulate. So there will be arrangements put in place before the transfer happens. This isn't regulating the transfer. And then it's saying you've got to balance the fact that once you've put these arrangements in place, query how we put those arrangements, query if it's a breach of European Union, breach of European law now not to have arrangements when we haven't got these countries in mind. And then it goes on to saying you've got to balance the risk that they might not be complied with against the national security. So I'm not sure that 929 is meant to be the means by which we comply with the European Convention. And secondly, if we don't currently plan to give things to countries other than the ones we've already got arrangements with, whether it's a breach of the Convention not to have arrangements in place now, just in case we do decide to do it later.
I think my submissions substantially agree with quite a lot of what my lord's putting to me.
Oh.
I'm only relying on this code of practice to show that this code of practice does not introduce the safeguards either.
No.
And if anything, it contemplates what appears to be a more permissive regime than the extensive restrictions that persuaded the Grand Chamber under Ripper.
But would it be a breach of the Convention not to make arrangements with countries when we have no current plans to give them information?
No, of course not. It's simply that if information is to be shared, there are minimum safeguards. And what I say is that there's no hint of those safeguards, either as a mandatory requirement on the face of the statute or in the code of practice. And my lord is putting to me, well, perhaps some of these provisions of the code of practice are actually dealing with slightly different issues. And I say, well, maybe that's right. But the important fact is that nothing in the code of practice contributes to meeting those safeguards. And this is a modern code of practice which postdates Big Brother Watch. I hope that's a fair answer to the points my lord put. My lady, my lords, those are the points which I was going to deal with in relation to the convention. Points 4 and 5 will be dealt with in due course if that's convenient by Mr. Heaton. Can I move on to the EU law grounds? Now. One of the notable differences between the Strasbourg jurisprudence and the Luxembourg jurisprudence is that the Luxembourg jurisprudence has tended to go a bit further, not a lot further, but a little bit further in terms of safeguards and protections than the European Court of Human Rights. And a question that has often been asked, including in one case asked directly by the Investigatory Powers Tribunal in this country to the Luxembourg Court, is why are you going slightly further in the protection that you've offered? And the answer, which the Court of Justice always gave, is that there is actually a difference between the applicable legal regimes. And the difference in the applicable legal regimes is the right in Article 8 of the Charter, which is the right of data protection, which exists as a fundamental right in the European Union, but is not the subject of any separate provision in the European Convention on Human Rights. So just before I turn to what the grounds are, if I could show the Court briefly the relevant legislative regime, starting with the Charter. The Charter is at tab 72 of the authorities, page 3376. Article 7 of the Charter is the equivalent of Article 8 of the Convention, with the right to respect for private and family life. The only difference in wording is correspondence in the Convention has been changed to communications in the Charter, slightly modernised. But Article 8 has no parallel in the text of the European Convention on Human Rights. It's the right to protection of personal data. And in particular, Article 8, subsection 3, provides that compliance with these rules shall be subject to control by an independent authority. And that perhaps explains why the Court of Justice has been slightly quicker to insist on prior independent authorisation in certain cases than the Strasbourg Court. Article 52 of the Charter, and that's page 3379, deals with the scope and interpretation of rights and principles, and the requirement in subsection 1, or subarticle 1, is that limitations of course have to be provided for in law, respect the essence of the rights and freedoms, and be necessary and meet objectives of general interest. So that reflects the balancing of rights that one sees in the European Convention, in, for example, Article 8.2. And then Article 52.3 deals with the European Convention on Human Rights, and it says the meaning and scope of those rights, where there's a corresponding provision in the Charter rights should be the same as those laid down in the Convention, but it doesn't prevent Union law from providing more extensive protection. So the European Convention on Human Rights, where there's a corresponding provision, provides a baseline. It's also common ground that in this case, despite the EU Withdrawal Act, because of the date on which the claim was issued, the Charter continues to apply to the determination of the case. The Divisional Court in its 2022 judgment gave an explanation of those provisions that I don't think is in dispute. That's the Charter. The legislation, which continues to be in place as retained EU law, the key bit is the e-privacy directive. The e-privacy directive is at tab 74 of the authorities, page 3400. And there are two important provisions. Article 5 at page 3406. Article 5 prohibits listening, tapping, storage, other forms of interception or surveillance unless it's been authorised under Article 15.1. And Article 15.1 provides a derogation provision. It's page 3409. What it explains is that member states may adopt legislative measures to restrict rights and obligations subject to the usual requirements of necessity and proportionality and so on. It's a fairly simple legislative regime. Now, that quite simple legislative regime has led to an extraordinary amount of litigation. Where that litigation has ended up most recently is in two judgments of the Court of Justice. First of all, in the Privacy International case, which was a reference from the Investigatory Powers Tribunal here, and also in the La Quadrature du Net case, which was a series of joined references from France and Belgium. The way it all started was that the European Union passed a directive requiring member states to retain communications, to impose requirements retaining communications data. So the idea was that there ought to be a harmonised scheme across the European Union under which all communications providers across the European Union would retain their communications data for the same minimum period and subject to the same rules. And that was thought to be a beneficial provision because communications data service providers may operate over borders. Vodafone, for example, has operations in many European countries, and so a harmonised regime for retaining communications data is beneficial. There was then a case called Digital Rights Ireland, where the Court of Justice said no, those arrangements were unlawful, and they were unlawful because they provided for what the court called general and indiscriminate retention. And on top of that, there were not adequate safeguards. There needed to be prior independent authorisation before the data was accessed. So that directive was quashed by the Court of Justice. The immediate response of pretty much every member state was to pass their own legislation providing for retention of communications data. So in the United Kingdom, that legislation was DRIPA, the Data Retention and Investigatory Powers Act, which also did not contain any requirement for prior independent authorisation for access. It was challenged by Mr. Watson MP and Mr. Davis MP. By the time the case got to the Court of Justice, it was called Watson because Mr. Davis had become a Secretary of State and so wasn't able to be on both sides of the litigation. And it was joined with a Swedish case, Telly 2. And in that case, the Court of Justice found that the Swedish legislation was general and indiscriminate and therefore unacceptable, and also didn't contain the safeguards necessary. And the Court of Justice wasn't asked to consider whether the UK legislation was general and indiscriminate, but also found it lacked the necessary safeguards. So that's the position prior to the Investigatory Powers Act. Then what happened is there was a reference from the Investigatory Powers Tribunal in the Privacy International case. And that reference was about what we now call bulk acquisition. So an order to a communications company saying, in effect, hand over your communications data, all of it, on a rolling basis to the intelligence services. And before the Investigatory Powers Act, that was conducted in the United Kingdom under some slightly obscure provisions of the Telecommunications Act 1984, which permitted the Secretary of State to give a national security direction to a telecoms provider. And that's how the power was being exercised. The Court of Justice concluded that those arrangements were within the scope of EU law and contrary to EU law. And that led to findings to that effect in the Investigatory Powers Tribunal. And on the same day that Privacy International was decided, the Court of Justice produced another judgment dealing with a range of other legislation in Belgium and France concerning various different types of retention and analysis by all sorts of telecoms companies for various purposes. National security purposes sometimes, criminal purposes other times. So it's those two cases, Privacy International and the French and Belgian case called La Quadrature du Net, that are now the main sources of law in this area. What the Divisional Court did is the Divisional Court decided, first of all, that the bulk regimes in the Investigatory Powers Act were not general and indiscriminate in nature. Now, if they were general and indiscriminate, that doesn't mean that they were prohibited, it just means that a particular suite of safeguards needed to be applied to them. But the court decided they were not general and indiscriminate. The court also decided, first of all in 2018, that the Court of Justice meant what it said about prior independent authorisation when accessing communications data for criminal investigations. And that led to the creation, and that hasn't been appealed, and that led to the creation of OCTA and the introduction of independent authorisation for criminal law, criminal purpose access to communications data. and that's already been rolled out. That has happened. And then finally, in 2022, the Divisional Court considered what happens where the intelligence services want to get access to communications data under Part 3. And the stance of the intelligence services is that even where they were acting for purely criminal investigatory purposes, and the agencies do purely criminal investigatory work, for example in drugs trafficking cases, the agencies contended it wasn't necessary for them to comply with those minimum safeguards of prior independent authorisation, and the Divisional Court said yes, when they were acting for a criminal purpose, they do have to comply. Again, that hasn't been appealed, and amending legislation has been introduced. So that's a potted history of the state of play. There are now, mercifully, only 3 points remaining, the 3 EU grounds. The first EU ground is about the limits on what a regime, general and indiscriminate regime, as the Court of Justice call it, can be used for. The Divisional Court said that the bulk powers were not general and indiscriminate. They didn't need to meet those requirements. And so the questions for this court are, first of all, whether the Divisional Court was right about that, and if the Divisional Court were not right, what that means in practice. That's the first ground. The second ground is about where the agencies use their bulk powers for the purposes of criminal investigatory work. So the court has heard the context of that. Where the targeted power in Part 3 is being used to obtain communications data, it's now common ground that the agencies, just like the police or a local authority, have to go off to OCTA, have to go off to the Investigatory Powers Commissioner and get a prior authorisation, except in urgent cases. The difference for the agencies is that in practice they don't need to do that, because they're likely to have a comprehensive data set of, at the very least, communications data as a result of their bulk acquisition powers. And again, this is a similar point about rolling out the logical consequences of the argument to the different powers. That where a bulk power is being used for criminal investigative purposes, when it could be that another power that would require authorisation could be used, authorisation is needed for the bulk power as well, for getting the same access. And this is the corollary of the same sort of arguments in relation to journalistic source material, which I've already sought to develop. It's simply saying that where you use a bulk power to obtain information, which if you did it under a specific power would require independent authorisation, you still require that same independent authorisation for the same reason. Now, this is an argument that, I make clear, does not apply to the national security activities of the agencies. And the reason for that is because that's what the Court of Justice said in La Quadrature du Net, that there is quite an important distinction between the need for prior authorisation in national security and non-national security cases. So this is an argument which has a limited effect, but we say an important one. Then the final aspect of the EU law point is that we say that the breaches of the Convention, the European Convention on Human Rights, that I've already sought to identify, and which in part are conceded, are also breaches of retained EU law. And we say that because our submission is that the rights under EU law including the Charter, cover as a baseline minimum the same rights and obligations as exist under the Convention.
And this is on the remedies point.
And it's relevant, well, exactly right, to remedies, because under the European Convention on Human Rights, the remedy the court, if the court grants a remedy, it's of course discretionary, would be a declaration of incompatibility. Under retained EU law, the court has the power to disapply the relevant provisions, perhaps after waiting an appropriate period to allow the government the opportunity to rectify the defects if it wishes to do so. And as the court will have seen from the 2018 Divisional Court judgment, that's exactly what the Divisional Court did with the agreement of all of the parties.
That's in relation to Part 4.
Yes, that was in relation to Part 4. So the court suspended the effect of its declaration for a period of months to allow a lawful regime to be put in place. And because that required setting up a whole new independent agency, that suspension had to last necessarily for a little while. But nonetheless, the court has different powers under retained EU law than it does under the Convention. And where we say the Divisional Court went wrong is the Divisional Court entered into, and I mean this genuinely, actually an interesting discussion about the extent to which Strasbourg authority bound the Court of Justice, but never actually addressed the real issue for the appellants, which was whether in fact there was a breach of retained EU law.
Your case is there's a breach of EU retained law, and just look, it's confirmed by the fact that the Convention's been breached.
Yes.
It's not that you enforce the Convention judgment by the Charter.
We say that is an interesting issue, and one can see how it could arise in another case. But we say in this case, all that has happened is that we say, well, in addition to there being a breach of the Convention, actually the same points also hold good as a matter of retained EU law. And that's the point which the Divisional Court didn't actually make a decision on ultimately. We say that was the error which the Divisional Court made. And as to what the answer to the question is, we say the answer to the question is not very difficult. There's no doubt that retained EU law will provide at least the same level of protection and safeguards, as is apparent from the Court of Justice's case law of the last decade. The Court of Justice has cheerfully looked at the Strasbourg case law and said yes and, rather than no. So it's an issue which we say is relatively straightforward. Can I deal with those in a tiny bit more detail in turn? The first ground relates to the issue of general and indiscriminate retention. I think there are 4 questions that I'll need to say something about. The first is, I've been bandying around this concept of general and indiscriminate retention. What does it actually mean, and what does the case law of the Court of Justice actually say about it? The second question is whether the bulk powers here are general and indiscriminate in nature. The third point is, if they are general and indiscriminate, what does that actually mean in law? What are the safeguards that are required? And then finally, why do we say that the Divisional Court erred on this issue? So if I may, I'll start with the question of what general and indiscriminate means. The most recent detailed explanation from the Court of Justice is in the Privacy International case. That's in Authorities tab 17. And it starts at page 613. If I can pick up the judgment at page 633 of the bundle numbering, where the Court of Justice sets out.
Sorry, what was the?
Tab 17, page 633. paragraph 16 of the Court of Justice's judgment sets out the relevant domestic law, and as I said, it was the Telecommunications Act 1994 which gave the Secretary of State the power to make directions in the interests of national security. And notably, subsection 2A, capital A, there was a duty on the Secretary of State not to give a direction unless he believes that the conduct is proportionate. That was added to the Telecommunications Act by Ripper on the day the Human Rights Act came into force, no doubt for that reason. The way that power was used was explained by the court in paragraph 20 of the judgment, between letters D and E. And between D and E, the Court of Justice say, in that context, the security and intelligence agencies would also use bulk communications data acquired from providers of public electronic communications networks under inter alia directions under Section 94 of the 1984 Act. And GCHQ and MI5 have been doing this since 2001 and 2005, respectively. So that was what was happening in practice before the Investigatory Powers Act, and this was the legislative basis. Then, over the page at 636, paragraph 24, the Court of Justice explained the difference between this reference and previous references they've heard, and they point out that the difference between cases such as Telly 2, that's Mr. Watson MP's case, is that the present case is about handing over the data in its entirety to the intelligence services, and it concerns national security, whereas the previous cases concerned retention by the telecoms company and criminal investigations. So it marks a development in the court's case law because it's considering the handing over of data in its entirety, what's in effect a bulk power, and also national security matters rather than just criminal investigations. And that becomes particularly clear from paragraph 25, where there's a description of the order for reference. The referring court, that's the IPT, adds the databases compiled by the agencies are subject to bulk, unspecific, automated processing with the aim of discovering unknown threats. The referring court states that the sets of metadata thus compiled should be as comprehensive as possible so as to have a haystack in order to find a needle hidden therein. And then there is a reference to Lord Anderson's report, which explains the importance and usefulness of the material. Now, that metaphor, having the haystack in order to find the needle, was indeed contained in the order for reference. I think the metaphor was actually my learned friend Sir James's, but it was picked up and adopted by the tribunals as a fair description of what was in practice going on. So the aim of this technique and this power is not to get hold of just a small part of what is globally available in terms of communications data, but to get as comprehensive a bulk data set as is possible. You'll never get everything, of course, but doing what is realistically possible in order to collect the haystack. Then, in paragraph 29, on page 637, the court sets out the questions that are referred and the findings of fact of the Investigatory Powers Tribunal by quoting the order for reference. I don't need to go through that lengthy quote, but it is fair to say from the drafting of the order for reference that the view of the tribunal was that EU law was not engaged, and that the safeguards that had previously been identified in the Court of Justice's case law ought not to apply. And the Court of Justice disagreed, and first of all held that EU law was engaged. That's paragraph 41 of the judgment, page 640. And what said is the disclosure of personal data by transmission, like the storage or otherwise making available the data, constitutes processing for the purposes of Article 3 of the e-Privacy Directive, and thus and accordingly falls within the scope of that directive.
What were they referring to when they said disclosure of personal data by transmission? What's that a reference to?
That's a reference to the order to the communications company to hand over the bulk data set. So the order under Section 94 of the Telecoms Act saying, please give us all of your comms data on a rolling basis. Thank you very much. And that is an order for transmission, so that engages you.
Thank you.
The next question is question 2 on page 641, paragraph 50. Is that the question of whether the national legislation is precluded if it requires what the court calls general and indiscriminate transmission of traffic data and location data for the security and intelligence agencies for the purpose of safeguarding national security. So that's the question which is then considered, and that wasn't the exact question in the order for reference, but the court reframed it, as it sometimes does. And what the court says about that at paragraph 52 is the disclosure of data by transmission concerns all users of means of electronic communication without it being specified whether that transmission must take place in real time or subsequently. And then once transmitted, that data is retained and is used by the agencies, subject to bulk automated processing and analysis, cross-check, and so on and so on. And then at the end of 52, no prior authorisation from a court or independent administrative authority, no notification of persons concerned in any way. So that's the court's understanding of the type of bulk power that was at issue. Then at paragraph 69, the court deals with the question of what the nature of that power is, analysed under EU law. That's page 645. And between letters F and G on 645, the court concludes the way the operation is carried out, as in the present case, in a general and indiscriminate way, it has the effect of making the exception to the obligation of principle to ensure the confidentiality of data the rule, whereas the system established by the e-Privacy Directive requires that the exception remain an exception.
Sorry, which paragraph is that?
That's paragraph 69 between letters F and G. Now, that is not again to say that it can't be done. The court then, over the page at paragraph 75, page 646, refers to its judgment handed down the same day in La Quadrature du Net to explain that there are circumstances in which that can be permissible. And the court then summarises that decision and some of its other cases as to when it can be done. But what the court is doing here is it's concluding that that power under the Telecommunications Act was a power that was being used in a general and indiscriminate way in the language it uses. And that is confirmed, if there's any doubt, at paragraph 80 of the court's judgment, page 647. Where the court says that the transmission of traffic data and location data is carried out in a general and indiscriminate way. And it's just worth adding there that the communications data that was being transferred wasn't just who called who, but it was, for example, continuous data about the location of everyone's mobile phone. So very granular and potentially very sensitive. and the court concludes that that is a general and indiscriminate activity. It's comprehensive in that it affects all persons using electronic communication services and applies to persons for whom there's no evidence to suggest their conduct may have a link, even an indirect or remote one, with the objective of safeguarding national security, and no relationship between the data transmitted and the threat to national security. So we say that paragraph 80 contains a useful and practicable working definition of what the court means when it talks about general and indiscriminate powers. When the court talks about general and indiscriminate powers, it's not doing it in a pejorative way. It's not saying that there's something fundamentally and necessarily wrong with it. It just says that that is a type of power which it requires to have particularly stringent safeguards.
Well, it does look rather pejorative from what's said in 81.
Well, it does criticise here this scheme as being beyond what's strictly necessary and not justified within a democratic society.
Well, it follows the national legislation requiring providers to disclose, etc.
Yes.
By means of general and
And the nature of the scheme that was operated under that legislation was, of course, quite a serious one. There's no hint on the face of the legislation that that is what was being done with the general national security power. And the fact that such directions were made was kept entirely secret for many years, and it was only found out as a result of disclosures by a journalist. It wasn't the Snowden disclosures. It was Gordon Ferreira, a BBC journalist, who wrote about it first of all, and it was disclosed to him and he wrote about it publicly, and that led to a claim in the IPT, and it led to the disclosure of the existence of the technique. So it was a technique that was in practice being used secretly, and it's perhaps not surprising that in the circumstances it was held to be a general and indiscriminate use of the power.
But the power here is such directions with general characters appear to be necessary, and unless I misunderstood, the Secretary decided that all the telecommunications data of everyone now, and as it is coming in over the subsequent months and years, everything's got to be handed over. There wasn't anything left that wasn't handed over.
That was certainly the aim. Of course, we haven't seen the actual direction.
No, but that seems to be what they're after, everything.
But the aim, and we can use the imprecise metaphor, is to collect a haystack to find the needle.
Or just to collect every piece of straw going.
Yes. That was the aim.
Yeah.
And we say that is an analogous principle to that applies under the bulk powers here. And the reason for that is that for the bulk powers to be effective, it's necessary to have as comprehensive a data set as is realistically possible. So take the bulk acquisition power, which is the successor to this power in the Telecommunications Act. The agencies will want and consider it proportionate to have the same comprehensive data set they considered before, so as to be able to make rapid and complete searches against it. So if the agencies previously thought it was necessary to have, for example, the location data of every mobile phone in the United Kingdom, it's unlikely they'll have changed their mind. And one understands why they say that that's necessary and proportionate. And that's because there will be requirements for them to conduct large-scale scanning in order to find unknown threats or to be able to identify particular threats at pace.
But I'd have to go back and read the Act again, the IPA. I mean, you can't just get absolutely everything forever. Can you now, under Part 6, Chapter 1 and Part 6, you've got to go through the safeguards to make sure that you've justified what you're getting.
Yes, you do have
It's
to
different from the Section 94 power, wasn't it?
But no, it's no different, we say, from the Section 94 power, because under the Section 94 power you had to justify, the Secretary of State had to justify what he or she was getting as proportionate. So there was still a constraint under the Section 94 power that what was being obtained had to be proportionate, and that was of course introduced on the same day as the Human Rights Act came into force in order to ensure convention compliance. So, but the important point is that it may well be proportionate and necessary to collect a complete data set. And that's the nature, we say, of a bulk power. The whole point of a bulk power.
But does it follow it's general and indiscriminate if it has to, the hoops have to be gone through? That's your argument.
Yes. The argument is the nature of these bulk powers is such that the way in which they are intended to be used is to be intended to be used in a way which is as comprehensive as possible, so as to ensure their maximum effectiveness. And under the old legislation, there was a constraint of proportionality, and in the new legislation, there's a constraint of proportionality, and there are also other provisions that say, in effect, you shouldn't take more than you need, and you should tailor to the extent you can. However, there is no prohibition on taking a comprehensive data set, a general data set or an indiscriminate data set, and the position of the respondents has always been that it may well be necessary to obtain such a comprehensive data set in order to achieve the national security or public protection purposes that are being pursued. The Court of Justice doesn't say that's prohibited, but it does say that there are different requirements that apply. And so they've categorised particular powers as being general and indiscriminate, or not general and indiscriminate, depending on, in essence, whether they are what I would call bulk powers or non-bulk powers.
I tend to think of indiscriminate as not having differentiation as between different bits of information. And I thought that when you showed us this morning all the acts, there was lots of things saying what you could get it for and what you can't get it for and so on. General seems to me to be everything without thought. And this might end up with everything, but is it without thought?
Well, that is the reasoning of the Divisional Court. The Divisional Court thought that you could prevent a power from being a general and indiscriminate power by introducing a requirement for the decision maker to think about limitations and safeguards. And we say that isn't the approach that's taken by the Court of Justice, because the Court of Justice considered a power in Section 94 of the Telecoms Act that did have limitations and safeguards. They may not have been as good as they were in the Investigatory Powers Act, but there were such limitations and safeguards. But nonetheless, the court thought the power was general and indiscriminate because, and it looked at the substance rather than the form, the aim was to collect as comprehensive a data set as possible.
What was the date of this case?
The Privacy International case.
October the 6th, 2020 judgment.
Yes.
2020.
Can you just remind me, are we bound by this? Can we depart from this? Do we have regard to this? I've lost track now.
Yes, the judgment in Privacy International was handed down before the IP completion date.
Right.
And so, therefore, it is subject to, this court is bound by it, but it may depart from it if the test applied by the Supreme Court for departing from one of its own decisions is met. That's the effect of the regulations made under the EU Withdrawal Act 2018. Yeah. Again, they're summarised in the Divisional Court's 2022 judgment. So it's binding, but only to that effect, that this court is in effect the Supreme Court for these purposes. There are some later decisions which are not binding, but the court may have regard to them. What I'll do is, can I just identify where I'm going to go next, and then that might be a convenient time to break for the day. The second point, and I've already started to develop it, is that this scheme is the same, because the aim of, for example, the bulk acquisition provisions.
When you say this scheme is the same, which scheme?
The scheme of the Investigatory Powers Act.
So this is the same as Section 94?
The same as Section 94. That there's no indication that the aim and intention of it is any different, namely to collect the haystack to find the needle. And under both schemes, the Secretary of State's decision must be tailored to what's proportionate. And there is a logical reason which is put forward, which is that the Secretary of State does want to collect as complete a data set as possible. And it's that nature of the scheme that makes it general and indiscriminate. Lady Reynolds, that might be, if it's a convenient moment,
Yes,
to
it's been
break.
quite a dense day, I think.
It is quite a dense day. The good news is that for what it's worth, I think I and my learned friends are on track to finish well on time.
Good. Right. We'll sit again tomorrow.